Welcome to today's show. I am your host, Eric Darnley Small. Thank you very much for joining me today. This is going to be a quick one. I just wanted to go over some very interesting court cases. I don't usually do court cases, not very often, but I am going to start doing them because we're starting to get into June, and right around now, the court is going to start coming out with decisions that based on cases that they've heard, and some very important cases have come through, and I don't want you to miss the importance of these cases and the importance of what's happening on the court, because they affect us dramatically. Particularly, we're in an election year. Very important that these cases come through. They have great deal of significance going forward. Probably the most significant one is a case out of Louisiana, and I think I talked about this previously on a previous episode, the importance of this case. And I haven't read this article. Normally I try to prepare before I do a video, having read the article, but I haven't, because this is somewhat breaking news. Well, not this particular case. This actually decision came out yesterday, but another one is breaking news. I haven't had the opportunity to go through it. However, this is very significant because, as I have said before, the conservative movement is, and in general, Republicans have been against women's rights, voting rights, LGBTQ rights, and importantly, unions or workers' rights. Right? They have taken assault on those rights, and they're trying to go back to a pre-1960s universe, 1960s world. That's their goal. And two cases that have come out just recently have indicated that. But this one is really important as well, and I want to go over it. So let's talk about this. First one, this is out of Politico, and this is a case that strikes to the heart of voting rights, right? The Republican Party, particularly in southern states, have been working very hard to try and shore up their ability, particularly in the House, to remain in power forever, even in southern states where there are a lot of African Americans, like Louisiana, Mississippi, and these places, Alabama, another one. Where there's a significant number of blacks. And the Voting Rights Act was there to address the attack on African Americans, particularly with respect to voting. The Voting Rights Act was there. There was pre-clearance. All of these different sections of the Voting Rights Act was to combat what, and at that point in time, it was Democrats were trying to do to prevent blacks from voting. So here, this is a ruling that came out. Supreme Court has put the effort to redraw Louisiana's congressional district for a second time since the last election on ice, clearing the way for a map that includes two majority black districts. Let me just, give again context here. This is a case as old as time. Again, the Supreme Court ruled, based on the Voting Rights Act, that this district and other districts that had been gerrymandered out of existence, that was predominantly black, most likely going to end up Democratic. They tried to get rid of them. Gerrymandering has been happening all over the nation. And what a lot of conservatives have been hoping with this super conservative court is that they would finally do away with the Voting Rights Act, find huge sections of it unconstitutional. And what you're seeing is all kinds of theories of, judicial theories, conservative theories being thrown to the wall to see if these conservatives will bite. And many times they have. But here, this was a very interesting one. And I'm going to go into reading this so that it can get the history of it. The ruling is a win for black voters and Democrats who are well positioned to pick up a new majority black seat in a deep red state. The Supreme Court order cited the principle that federal courts should not order states and localities to change election rules or district boundaries too close to voting. The court's three liberal justices, Sonia Sotomayor, Elena Kagan, Ketanji Brown Jackson, dissented from the ruling. Jackson's solo written dissent didn't necessarily question the outcome, but instead she wrote she believed the High Court's intervention was premature. The other two liberal justices did not explain their reasoning. It is unusual for the liberal justices to vote in a block to halt a plan to boost the number of states' congressional districts minority candidates are likely to win. However, some analysts have said those justices might be signaling concern about the High Court's recent tendency to block lower courts' election related orders under the rationale of not disturbing voting practices for a looming election, even when an election is not entirely imminent. Louisiana's long running fight over its congressional map is the most notable outstanding redistricting question of this November, for this November. A series of last minute redistricting moves across the country ahead of the November election gave Republicans a slight edge thanks largely to a GOP led North Carolina gerrymander that all but guaranteed a 3-seat pickup for the party. In 2022, a federal court ruled the map drawn by Republicans after the 2020 census likely diluted the power of black voters and ordered a second majority district to be drawn. The state legislature appealed, but ahead of the midterm elections, the Supreme Court put the case on hold. In the midterms, only one of the 6 congressional districts in the state was majority black and elected a Democrat. Around 1/3 of the state's population is black. The Supreme Court later restored that lower court's decision, and the state had to redraw its map to give black voters more power. Earlier this year, state lawmakers drew a new map that added the second majority black district by altering the 6th district held by Republican Gareth Graves, to snake across the state from northwest Louisiana all the way down to East Baton Rouge. The redrawn district criticism from House Speaker Mike Johnson, who fretted about Republicans losing a seat in his home state with the party's already thin majority. State Senator Cleo Fields, who served in Congress in the mid-1990s, is the most prominent Democrat in the race for the 6th district. Graves, who faced an uphill challenge under the new lines, said prior to the Supreme Court ruling that he's running for re-election in that district and not against a fellow Republican incumbent, and did not think the map would survive a court challenge. A group of self-identified, quote, non-black voters quickly challenged the new map, alleging that it was an impermissible racial gerrymander, just weeks before the state's self-imposed May 15th deadline to have a map in place. A split 3-judge federal panel sided with those, quote, non-black voters and struck down the new map lines. Despite the apparent political benefit of another new map, Republicans in the state had raised concerns about implementing new districts on such short notice or budgeting from the May 15th deadline. Secretary of State Nancy Landry warned that, quote, the risk of rushed election administration resulting in errors is significant if the deadline is not May 15th. The state's filing deadline is in July, and all-party primary is held at the November election. The judges seemed inclined towards creating more chaos in our congressional elections in a presidential election year, Republican State Attorney General Liz Murrill said last week. Murrill, who appealed the lower court ruling to the Supreme Court, argued that overturned map should be in place for this year's election. The Secretary of State has consistently stated that she needed the map by May 15th, Murrill said in a statement to Politico after Wednesday's ruling. The plaintiffs did not contest it at trial. We will continue to defend the law and are grateful the Supreme Court granted the stay, which will ensure we have stable election system. The second majority black district would be a boon for Democrats whose influence had waned in the state. So this is actually a fascinating thing because this is what happens when you have people. It's almost like the dog that caught the car, for instance, that old reference. This is what happens when you have people who are genuinely disingenuous about their whole reason for doing what it is they're doing, right? Who really don't believe in the rule of law, but believe in power and exercising power. And even people who are administrators, people who have the job to administrate the law, to administrate, in this case, elections, are saying you begin screwing with elections, screwing with the system, you're only going to cause more problems and more pain. And I think this is something to be aware of. This is a cautionary tale, but it's something to be very much aware of. As Donald Trump and Republicans think a Donald Trump administration, they're going to pass this 2025, um, uh, agenda. They think they're going to come in and whole cloth start taking the administrative state apart. You're going to get pushback, and it's not just going to be from Democrats, it's going to be from Republicans as well. Because just like with abortion, people don't want the government to go away. Rich people do, people who have power, people who are political, people who are activists, particularly who are against government and against the efficiency of government. They want the government to go away. But when the people begin to see the government and its resources going away and chaos created, you're going to get a backlash, and it's going to go across the board. So this people who are fretting about the 2025, this whole decision by what it is the so-called, you know, uh, Trump administration is going to do, just be aware that things appear easier than they really are. And this is going to become something that is much more difficult to do at the end of the day than people realize. Next up is I want to talk about this other case that was just decided earlier this morning, and that is regarding the CFPB. This is the baby of Elizabeth Warren, created by Elizabeth Warren, and it's an agency that is there to basically make sure that businesses are not running scams and are not screwing people, basically. And Republicans hate it. This comes out of Dodd-Frank. They have tried multiple times to attack the agency, to attack its funding. This time it was about its funding. Previously, it was about attacking how the head of the CFPB was chosen. The Supreme Court has pushed back on some of this stuff, and it appears as if they have pushed back once again. Excuse me, I want to bring this page up full page. I can't see how to do it very easily right now. So, okay, I can't do it. So I'm going to bring this up anyway. Okay, there it is. So the CFPB survives this action, and the Supreme Court rejected a challenge to the Consumer Watchdogs Agency's funding. A lot of people who observed the court and who observed this hearing were skeptical of of this attack against the CFPB. They were listening to the kind of questions and answers the judges were giving, and a lot of people who observed the court, a lot of people reporting on this, were very skeptical that the Supreme Court would do what these uh, plaintiffs had asked it to do, which is to strike down the entirety of the CFPB um, due to its funding mechanism. And it seemed as if the court was very skeptical, and it turns out they were right. I'm always skeptical about how people are reading the tea leaves of the court, and but on this one they were right. So I'm just going to go over briefly what this had to say. The Supreme Court rejected a challenge on Thursday to the way the Consumer Financial Protection Bureau is funded, one that could have hobbled the Bureau and advanced a central goal of the conservative legal movement, limiting the power of the independent agencies. The vote was 7-2, with Clarence Thomas writing the majority opinion. Surprise. I'm surprised by that. Had the Bureau lost, the court's ruling might have cast doubt on every regulation and enforcement action it had taken in its 13 years of existence, including ones concerning mortgages, credit cards, consumer loans, and banking. The central question in the case was whether the way the Congress chose to fund the Bureau had violated the Appropriations Clause of the Constitution, which says that, quote, no money shall be drawn from the Treasury but in consequence of appropriations made by law. Clarence Thomas said the mechanism was constitutional. Under the Appropriations Clause, he wrote, an appropriation is simply a law that authorizes expenditures from a specified source of public money for designated purposes. The statute that provides the Bureau's funding meets these requirements. We therefore conclude that the Bureau's funding mechanism does not violate the Appropriations Clause. Samuel Alito Jr., joined by Gorsuch, who's a big Gorsuch is a big hater on the administrative state, dissented. The Bureau, created after the financial crisis as part of the 2010 Dodd-Frank Act, is funded by the Federal Reserve System in an amount determined by the Bureau so long as the sum does not exceed 12% of the system's operating expenses. In 2022 fiscal year, the agency requested and received 641.5 million of the 734 million available. A unanimous three-judge panel of the U.S. Court of Appeals for the Fifth Circuit in New Orleans ruled in 2022 that the Bureau's funding mechanism or method ran afoul of the Appropriations Clause. The Fifth Circuit's decision was at odds with ones from other courts. In 2018, for instance, the District Court of Columbia Circuit said there was nothing unusual about the funding mechanism. In 2020, the Supreme Court ruled that a different part of the law created the Consumer Bureau was unconstitutional, saying that Congress could not insulate the Bureau's director from presidential oversight given the scope of the job's authority. He mentioned the Bureau's funding in passing, noting that its budget had exceeded $500 million in recent years. That's Chief Judge John Roberts saying that. Unlike most agencies, the Chief Judge wrote, the CFPB does not rely on annual appropriations process for funding. Instead, the CFPB receives funding directly from the Federal Reserve, which is itself funding outside the appropriations process through bank assessments. The case, Consumer Financial Protection Bureau v. Community Financial Services Association of America, number 2248, was brought by two trade groups representing payday lenders. They challenged a regulation limiting the number of times lenders can try to withdraw funds from borrowers' bank accounts. The Fifth Circuit struck down the regulation, saying that it was wholly drawn through the agency's unconstitutional funding scheme. So, there you go. A huge ruling, more so because of the makeup of the court, and more so because of people like Neil Gorsuch were put on the court and Alito were put on the court to attack the government's ability to do things like protect the people from scams, from businesses that are looking to rip people off, from excessive fees. You know, that's another area. I believe the CFPB is going after Ticketmaster over its outrageous ticketing fees and all these kind of things. So the CFPB exists as a way for the American people to be protected against businesses, payday loans, banking fees, airline fees. I think is going to be the next one they're going to attack. So it is definitely a business, a government agency that was created for the people to protect them against businesses. That's why conservatives hate it so much. That's why it was so important that it be allowed to continue. This is one reason why I supported Elizabeth Warren over Joe Biden during the election. I believe that these are the kinds of things that show true leadership and true ability to, to pass good laws that will survive any reasonable attempt to undo them. We know now that there are a number of judges who don't give a rat's ass and will continue to fight against the ability for, against precedent, against the ability for the government to do anything. And if Donald Trump gets in, he's going to put in more judges, probably try to expand the Supreme Court, try to do other things to try and make it much more difficult for average everyday Americans to, to survive and to fight back. Particularly in a time where we're trying to do something about a warming climate and all that that's created. So Two very good rulings out of the Supreme Court. And again, particularly because this is a very conservative, the most conservative court in a long time. And I don't expect good things to happen. And when they do, I want to report about it. And I want to make sure you do not miss it. Thank you very much for watching this episode. And you'll see me on the next episode of What You Missed. Hey there, fantastic viewers. Eric Darnley Small here. And I hope you're loving today's episode of What You Missed. You've reached the end of today's show, but don't worry, there's more show coming up. If you're watching this on YouTube, please click the bell so that you'll be notified when more content is available. You can also help the channel by clicking the like and subscribe buttons. It helps the YouTube algorithm find new viewers so that I can keep bringing you all this incredible content you enjoy. But wait, there are more ways to support the show. You can make a contribution through the show's PayPal, which goes a long way in helping produce even better content for you. And consider becoming a part of our growing community by joining our Mastodon site at mastodon.vtip.me/@whatyoumissed for more engaging discussions and exclusive updates. And here's something you won't want to miss. Mark your calendars for our live show streaming on YouTube and stream.vtip.me Monday mornings, 10:30 a.m. Eastern Standard Time. Your support means the world to me, and together we're making What You Missed the best it can be. Thanks for being a part of my journey.